My name's Christopher Hurley. I'm president of the Illinois Trial Lawyers Association, and I'm here on behalf of thousands of Illinois trial lawyers, but more importantly, I'm here on behalf of hundreds of thousands of ordinary Illinois citizens who will and have in the past found themselves injured on the job and will in the future find themselves injured on the job. And so it's important that we recognize that these are regular working people making a middle-class wage and who, when they are injured on the job, it's often a devastating occurrence which, if they are not able to get decent, fair benefits, will have hardship which may push them and their families into poverty. The simple fact of the matter about this bill is that it does reduce benefits, and in doing so, it makes it more profitable to do business in this state for insurance companies. We have seen the 2011 bill take effect, and as a part of that bill, there was a substantial reduction in the ability to recover for carpal tunnel injuries. There were a number of other benefit reductions, and there was a reduction in fees that doctors were able to be paid by 30%. Since 2011, annual claims are down 16%. Benefits paid per claim are down 8%. And compensable injuries in Illinois are now substantially below the national average. The National Council on Compensation Insurance has recommended a decrease in premiums for our state of 30%. That has not happened. So the result of the 2011 bill is that workers' benefits have been reduced and insurers' profits have increased. That's not what should be happening here.
I just talked to Dave. He's fine with taking it out.
The Illinois trial lawyers are in favor of a healthy and vibrant business community where businesses can prosper in this state. But we believe that safety and human decency is good business, and businesses and workers thrive in safe work environments. We're not in favor of a work environment where life is cheap and running an unsafe work environment has no consequences. Taking away a worker's benefits when he's hurt is simply going to push families into poverty, and somebody's going to have to pay the bill on that. And that's going to end up being the taxpayer or some other social service organization, because if somebody's been working and can no longer work and is not able to get workers' compensation benefits, somebody's going to have to help pay for that person's bills. One of the provisions of this particular bill is that it reduces the money that is paid to doctors for injured workers. This was already done to the extent of 30% across the board cut back in 2011. It's being, this bill proposes an additional 10 to 15% reduction to payment to doctors. But there's no showing whatsoever as to what's going to happen to workers who need doctors as a result of a further cut. Is there going to be a reduction in the number of doctors that are willing to see injured workers? Are injured workers going to not be able to get decent quality care practitioners, and why shouldn't an injured worker have the same opportunity to get good care as anybody else? So finally, I would like to say that while that the bill is a reduction in benefits for workers, and it does not include in it anything to address the fact that insurance companies will make more and have been making more because of prior such changes to the workers' compensation laws. And that is not an acceptable solution for workers in this state. Thank you.
Thank you, Mr. Hurley. Mr. Manchetti, did you have independent testimony, or are you available for questions? Either way.
Senator, my name is Dave Manchetti, and I'm a lawyer who represents injured workers.
Can you pull that microphone a little bit closer to
I also
you?
happen to be the technical advisor to the state AFL-CIO on workers' compensation issues, so I'm happy to answer any technical questions about the provisions in the bill, as boring as that might be for all of you.
Great. And if you could fill a witness slip out for us after we're done, that would be great.
Thank you.
Mr. Gordon, are you testifying on behalf of provisions unrelated to the NFL, the provision that's of interest to the NFL players?
No.
All right, we're going to devote a panel to that provision, if we can do it that way, if that's all right with you and Mr.
Whatever
Hurley.
the
Okay.
committee would prefer.
Okay. Are there questions for this panel of witnesses? Senator Raoul.
There was mention of compensation being below the national average. I'm just curious as what that is based on.
I believe it comes from the National Council on Compensation Insurance, who keeps those statistics, and essentially our state has compensable injuries which are below the national average.
And just one comment, Mr. Chairman, and it was something that I intended on saying earlier. Alita Redonia had mentioned earlier trying to target being at the middle of the pack. With all due respect to the leader, I think it's a dangerous thing to target being at the middle of the pack, because as our National Department of Labor has pointed out, as well as, I think there was a Sun-Times editorial a few days ago, we have to be cautious. While we should continuously seek to move towards reform, we should be cautious as to not engage in a race to the bottom, such that we say simply that another state is undercompensating injured employees, that we want to be somewhere near them, notwithstanding that there'll be injured employees left without recourse as a result of the policies that we embrace.
Don?
Senator Redonia.
Okay, just a comment, and actually a good segue from what Senator Raoul said. The one issue that you raised about the 3 to 5 day waiting period, it is my understanding that most states are 5 to 7, that we were, again, very low. And while I agree we don't want to race to the bottom, right now we are, we've gone from 3 to 8. I think we have a little room to be more competitive. The flip side of that being, we want to encourage businesses to locate here. So, again, since we're choosing 5 as the waiting period instead of 7, going up from 3, I don't see that as us rushing to disadvantage workers, but rather bring it in line with what is typical behavior in other states. Thank you.
Other questions for this panel? Just one final question. The ranking of Illinois relative to other states and the movement from 3 to 8, just unpacking that a little bit, a big piece of the cost driver for workers' compensation is the relative wages of employees. That's the payroll that triggers the premium and whatnot. And Illinois is and wants to remain well above the average nationally. Is that ranking adjusted for our payroll relative to other states?
Do you know? I don't believe that.
Well, no, it's not, because it's baked into that figure. So I think what you're referring to, Senator, is the Oregon study. And what the Oregon study comes up with is what's called an index rate. And that index rate is based on $100 per payroll. So I don't remember exactly what it is in Illinois, but it's something like $2.65 per $100 of payroll. But baked into that $2.65 is our level of benefits, the Illinois level of benefits. And of course, Illinois benefits are based on our injured workers' average weekly wages. And Illinois has a relatively high state average weekly wage. So yes, that index rate that Oregon comes up with has baked into it, so to speak, the level of Illinois wages, because our benefits are based on wages, both on the temporary total disability side and on the permanency side. So yes, it's baked into that.
And is
index rate.
the number 8 ranking that we were last reported, does that factor in that index, or is there a separate ranking that factors that in?
That's based on that index rate
Okay.
that I just talked to you about. And by the way, Senator, just so that everybody is clear, if you read that report itself very carefully, that report itself says to be very careful about using those index rates to rank states, because there's a lot of things that just are simply not accounted for in coming up with that index rate. So the report itself says this should not be used to compare apples to apples, so to speak.
All right, if there are no further questions for this panel, thank you very much for your time here today. We'll next turn to the Illinois Health and Hospital Association and the Illinois State Medical Society. If we could bring those witnesses up to the table.
Thank you very much, Chairman Harmon, Senator, President Cullerton, and Leader Radonio, and members of this committee for allowing me to express concerns that we have to further cuts to the medical fee schedule. I first want to thank the committee and the Senate and Leader Radonio for not creating a new fee schedule based on a percentage of Medicare. That would have really blown up the entire system and been incredibly detrimental to access to health care. That being said, I think I would be remiss if I didn't quickly, remind again the members that 2011 reform was a huge hit to physicians. And part of that 2011 reform did include language to try to ease some of those hassle factors, including the electronic billing language, which is included in this language, and we certainly appreciate that. The problem is that in 2011 it was never enforced. So, as Senator Kwame Raoul stated, we do have that concern that further cuts to the specialties like surgical fees and pathology and radiology fees will create an access issue for the best of the best. And if injured workers can't get timely access to quality care, we firmly believe that what will happen is that their injuries will get worse, their return to work will increase, their delay in returning to work will increase, and it will be and there will be an overutilization of services, and that to us will be an increased cost for employers. Why is worker compensation patients are extremely different than treating a Medicare patient or a group health patient? There are a number of hassle factors that physicians have to, or hurdles that physicians have to go through in treating injured workers, including dealing with nurse case managers, utilization review physicians, complicated prior authorization systems, and today still dealing with a paper-based health worker comp insurance system. So when we get a claim, we have to physically use like snail mail to mail that claim in. And what often happens is care is delayed to the injured worker, and physicians currently are not being paid in any sense of a timely manner. For a non-litigated claim, we go 284 days without being paid, and for a litigated claim, we're up to 2.5 years. So we're really being forced to be put in this position to, in essence, loan the system money, and that's something that we'd like to see rectified. So workers can get access to timely care, so their injuries don't get worse, so they can return to work earlier. I'm happy to answer any additional questions, but again, I certainly appreciate moving away from the Medicare-based fee schedule. I know that the business community would like to see, but we do remain concerned that further cuts could impede access for the injured worker. Thank you.
So to put it short, there's some of what you like in the bill and some of what you don't like in the bill.
Yeah, I mean, the electronic records or the electronic billing is something that we need. We have real problems with the insurance companies now because we have there's no advocate for us in the system. So the only thing we can do right now is to hire full-time staff just to track claims, just to hunt down our payments. And that's incredibly expensive for physicians to do. And so much of that could be eliminated if there was, I think, more focus on how do we create efficiencies within the insurance industry.
And I think Senator Radonio, to her credit, has, with the electronic billing, addressed at least part of your concern.
And we certainly appreciate it, so thank you for that.
Senator Harmon, back in chair.
Mr. Gross, are you up?
Yeah, Chairman Harmon, thank you very much, members of the committee. My name is Dave Gross. I'm a member of the Government Relations team for the Illinois Health and Hospital Association. And before I begin, I too would like to say thank you to Leader Radonio for her willingness to meet and discuss this legislation. Certainly appreciate the change that was made to not link the Medicare fee schedule to the workers' comp schedule. We still have concerns remaining in terms of using Medicare to try to identify so-called outliers. There's a variety of reasons not to do that, and we explain that in a memo that we provided to the members. Rather than go further on that memo, I will just take a quick moment to brief the committee about our general opposition. Our opposition really boils down to one word, and that word is uncertainty. We're uncertain that this proposal won't affect access to care for injured workers. Hospitals are the largest providers of health care to injured workers. Typically, the most severely injured workers who require the most extensive treatment come to the hospitals. Our greatest concern is for those patients and our ability to care for them. Further uncertainty exists in that the stated goal of this proposal will actually have its intended effect of lowering worker comp premiums. When cuts 3 times this size occurred in 2011, it did not move employer premiums down to the extent predicted. So why would more cuts have any impact other than to reduce access and drive up costs for employers? And of course, the uncertainty that exists, as Senator Raoul mentioned, it's uncertainty unrelated to this legislation, but important to this discussion, and that's the repeal of the Affordable Care Act. That's moving now in Congress. A vote is expected in late January this week or next, asking about the block granting of Medicaid and the possible loss of health care for more than 1 million citizens in Illinois, and with that, more than $12 billion worth of economic activity and possibly 90,000 health care related jobs. So these citizens who have obtained insurance, many for the first time, will continue to need and seek services, and this will strain hospital budgets, particularly our safety net and rural critical access hospitals. This will create a financial tipping point for many of our hospitals. The uncertainty that leads to all of this puts new investments, new hires, and new innovations on hold for a real bright spot in the Illinois economy. I think hospitals are major employers in many of your districts. 1 in 10 jobs are now in healthcare, and these are good jobs with good benefits. So our request on behalf of our 212 members of the IHA would respectfully ask the committee to allow the 2011 reforms more time to realize savings before embarking on another round of medical fee cuts, and to also delve deeper into the reasons why predicted savings from the 2011 legislation have yet to be realized in a substantial way for employers.
Welcome to the Senate Executive Committee.
Thank you, Mr. Chairman and members of the committee. I appreciate you having us here. My name is Richard Gordon. I'm an attorney in private practice in Chicago. I'm here to talk about how the Illinois Workers' Compensation Act should apply equally to all workers, like it does today. The bill that the part of the bill rather that I'm here to talk about is the change to Section 8D1 of the Act that would add language saying that while any worker in Illinois gets an 8D1 wage differential benefit to age 67, these guys don't, this group of professional athletes. So I own and operate a private law firm in Chicago, and I represent professional athletes in workers' compensation in Illinois. And just as a side note, this law that you're looking to pass here would probably affect 10 to 15% of my clients. And so we're really here to discuss today in 2017, with all the problems facing this state, a law that would affect a handful of workers per year out of a state labor force of 6.5 million. But I'm here to tell you that this bill is not just bad for my clients, it's bad for working men and women in your districts, and it's bad for the state of Illinois. Consider the Bears wide receiver for the Chicago Bears football team, whose jersey you bought for your kids to wear, who pays income tax in the state of Illinois, who pays real estate taxes here, who sows his roots in Illinois, who runs camps and programs for kids and donates his time and money to the community. That guy fractures his spine at work, making a catch on a NFL game that you watch on TV with your friends in your living room couch. This law says that he shouldn't get the same benefits that you get if you're injured at work, that he doesn't deserve the same protections for the dangerous job that he is employed in. This law draws an arbitrary line that says, over here we'll protect you, but if you're over here, if you're a professional athlete, then we'll treat you differently. And that's not what the Equal Protection Clause of the Illinois State Constitution is about. You know, I don't see too many 67-year-old welders or 67-year-old iron workers or cops or firemen. I don't see too many of those people those age in those professions. And if you pass a bill today that segregates one class of Illinois workers, how long until the business community comes back again and says we should carve out another group? And where do you draw the line? It's a very slippery slope. But it's a simple sell to the public here. The billionaire Bears owners say, well, why should the public care about millionaire athletes? And it's true, you know, a third of the Chicago Bears roster makes over $1 million annually, but 2/3 do not. And many of those make the league minimum. And if you're on the practice squad, which another dozen employees in Illinois are, you don't even make $100,000 a year. And no matter how much you make playing for the Chicago Bears, you put your body and your livelihood at risk every single day to be an entertainment product under a non-guaranteed contract. Now, this bill talks about professional athletes, and when you hear professional athletes, no doubt you're thinking about the Bears, the Bulls, the Cubs. But how about the Chicago Fire soccer team and their 25 Illinois employees, half of whom make less than $100,000 a year? Or the Chicago Sky, the women's basketball team in Chicago, with an average salary of $36,000 per year. Or the Chicago Wolves or the Rockford Ice Hogs, minor league hockey teams with $85,000 average salaries for 80 players, 80 Illinois employees. Or the 7 minor league baseball teams in Normal and Bloomington and Sauget and Marion and Schaumburg and Joliet and Rockford that employ nearly 200 Illinois employees. You know what they pay? Maximum $1,600 a month. There's another, there are hockey teams in Peoria and Quad Cities where those players make the same amount. That's who this law would hurt. And just to give you a concrete example, I represented a soccer player who played professionally for the Chicago Fire soccer team, who sustained 4 concussions in a short period of time, and was and his career ended because of those concussions, because of the brain injuries that caused. Now, this gentleman had a college degree, but because of the symptoms from those concussions, he can't make the same living that he would have been able to make if he went into the workforce out of college. And so he was making $50,000 a year playing for the Fire. Now he's capable of working a job making $35,000. And that's what Section 8D1 of the Workers' Compensation Act is here to do. It's to provide benefits to address that gap for all workers. But this law says that he doesn't deserve those benefits because his job is somehow different. You know, the reality is that this is a bill being pressed squarely by the Chicago Bears. And I think it's also important that you take note of the fact that Chicago Bears are a $2.7 billion business. Their value's up 10% since 2015. It's up 60% since 2014. And it's up 245% since 2011. Chicago Bears earned $350 million in revenue last year. Every year since 2001, the last 15 years, those revenues have increased. They get hundreds of millions of dollars a year from DirecTV alone. Hundreds of millions of dollars put in their pockets for a TV contract. The taxpayers of Illinois just gave them $430 million for a stadium renovation. And if you saw the papers today, you see that they're coming back with their hands out again saying that's not enough. Well, when is it enough? And let's not lose sight of the fact that the Bears are a self-insured entity. So even if you were to pass this law under the idea that you're somehow saving money for those businesses and that's going to go back to the insurance companies who are going to lower their premiums, that's not what's going to happen here. This money's going to go straight back into the McCaskey's pocket. Money for the McCaskey family, a bunch of lucky folks who did nothing more than get born with a good last name and an ownership of an NFL team. I brought with me here today Joe Briggs, Counsel and Director of Government Relations for the NFL Players Association, and he's here to testify further about the disparate treatment that this bill aims to promote. But before I leave, I just want to point out one more thing. Senator Radonio called this a cottage industry, somehow suggesting that there was no good faith in these claims. These are men and women who give their physical life to the entertainment that you watch on TV. They have every right to every protection that any other employee gets in this state. I'm happy to answer any questions the committee may have for me after that.
Thank you. Mr. Briggs, welcome to the Executive Committee. Before we testify, the State Journal Register has requested permission to photograph the committee hearing today. Seeing no objection, permission is granted. Mr. Briggs.
First, thank you very much for having me here today. My name again is Joe Briggs. I'm Public Policy Counsel and Director of Government Relations for the NFL Players Association. As my colleague, Mr. Gordon, has just mentioned, there are a number of concerns with the bill. The bill in its current form would treat players very differently from other employees within the state of Illinois, and we just don't think that that's right. We've fought this bill, the owners in different states around the country in several different jurisdictions, and time again the same thing came up, that NFL players make a bunch of money, and why should we care about them? Well, the reason you should care about them is because not all NFL players make a bunch of money. There's a kid that probably graduated from a little university here in the state of Illinois and get on a practice squad with maybe even the Chicago Bears. That player will make approximately $600 a week while he's in preseason. And if that player is unfortunate enough to have his spine broken while he's playing in those preseason games, he will need the benefit of workers' compensation within the state of Illinois. And those protections that are afforded to him should be the same protections that are afforded to the athletic trainer who's also at that same practice. But I'll give you, for instance, if that athletic trainer and that football player are both on a bus, let's say to practice one day, and that bus happens to get into an accident, and after that accident happens, both that athletic trainer and that football player are injured in a way that they can no longer work. Well, under this law, that football player would have his wage, his ability to apply for workers' compensation benefits cut to the age of 35. But that athletic trainer who's also on that same bus sitting in the seat next to him would have the ability to apply for benefits up to the age of 67. I cannot believe that that's what the good citizens of the state of Illinois want to have happen. Two people sitting side by side on a bus to have two different outcomes on the same law. I understand why there's some concern by some interested parties. Mr. Gordon has mentioned a few who may want to cut the cost of their own workers' compensation payouts. However, I do not understand why this would be considered a part of this state's budget because the dollar impact of this new legislation, if put into place by this legislature, would have almost no impact, if any impact on the state budget whatsoever. And therefore, I would ask that you take into consideration the words that we've said to you, and I'd be available to any questions that you or anyone else on the committee would have for us.
Thank you very much. Questions for this panel? Senator Raoul.
And probably just more of a comment to both the Senate President and Leader Radonio. And this is an honest feedback just from my history of negotiations and having conversations today. The last point raised with regards to this being a critical element with regards to the overall discussion of workers' comp as it impacts the state's costs. This element was just kind of a throw-in during the course of negotiations. And I'm not saying it's not worthy of the legislature having a conversation about it, but as an element that impacts the budget, unless the Bears are threatening to leave the state, which some of us might not have a great challenge with.
Good riddance.
Maybe compete for the Raiders. It's really not a critical component of workers' comp reform in the context that we've been talking about it as a package, and this is just kind of in the moment feedback based on my knowledge of both the 2011 negotiations, the working groups, as well as the the conversations that we've had solely in our chamber, and just as food for thought as conversations go on, perhaps this was one that we may want to, we could still have a bill on, but have in isolation.
Yeah, I mean, I think the testimony they provided with respect to, various situations makes sense. So I'm certainly willing to look at that. You're absolutely right. We think of professional athletes. We're thinking of those that are making, very high salaries that absolutely would not be making those salaries at age 67, because it is unique in that regard with athletes. I mean, we all deteriorate, whether we like to think it or not. So we can take a look at it and see if there's some refinements we could come up with. But since we're doing a work comp bill right now, I think it is worthy of seeing if we can address some of the concerns that you've raised, rather than maybe completely throw it out. But I'm willing to certainly take a look at it.
Thank you.
Senator Severson.
A couple questions. One is, how many other states have benefits the same as what Illinois does for coverage till 67, or how many states are as rich as what our Illinois' benefits are?
Well, just two things. First, thank you for the question. Second, I think that the way I would frame the answer to that question is that most states do exactly like Illinois, where they base the recovery under the Workers' Compensation Act on the average worker's wage, just like every other employee within the state. So it's not based on what an NFL player makes as some separate category. The benefits that are available to a person up to the age of retirement, that is typically the law throughout the United States of America. I'm not aware of another jurisdiction which places an age cap on the amount of recovery under workers' compensation. I know there have been several jurisdictions. I spent some time in the great state capital of North Carolina and also in the state capital of Louisiana in the last couple of years, where they tried to lower the ability to gain access to workers' compensation based on the wage of a person at the time they're injured, but those laws did not pass and were not successful, and in both of those jurisdictions they would treat you substantially similarly to the state of Illinois.
So you believe that the majority of other states have benefits as good as what we would have here, or cover as long as our current plan would cover them until 67? That's, you said the majority of states would be similar to that currently?
The majority of states treat athletes as workers because they are treated like all the other employees within that state, yes.
Okay. And most of the professional athletes, do they have disability contracts or disability as part of their contracts with them?
Depends on what you're asking. Are you asking if professional athletes have a separate disability contract?
Yeah, either separate for themselves or as part of their contract with their team. Do they have a separate disability policy or disability coverage with a carrier?
You know, if I can just address that, I can tell you that in my experience representing professional athletes in Illinois, none of them have anything in their contract that speaks to disability benefits. Some of them choose to go out in the marketplace on their own to pay exorbitantly high premiums for disability insurance, and they do that at their own cost. I can tell you that in my experience, that's a very low number, a low percentage, and that I don't believe that that's a realistic option as a consideration for this bill language, because of the fact that most of the athletes don't make nearly the amount of money that would, make it make good sense to purchase those kinds of insurance policies.
Okay, thank you.
Any other questions for this panel? If not, well, did you have a closing thought, Mr. Briggs?
I'd just say one other thing. It is our understanding that there are over 700 former and current NFL players that have connections to the state of Illinois. We understand we've received questions from several of our former players and even some of our current players about this legislation. They're very interested in why I'm here today. In addition to that, the National Basketball Players Association, National Hockey League Players Association, Major League Baseball Players Association have all sent me notes saying that they want to be here and they're very interested in this bill. So I just say that for the record.
Wonderful.
And the problem is that we've got a workers' compensation bill that is the primary pro-growth driver in this package, yet it falls woefully short of what we really need to be able to tell our members that, yes, we've got some things that are going to be good for the future, good for your business, and that merits a discussion about additional revenues. They're going to also come right out of your business at the same time. So we think that this package is woefully inadequate at this point to go ahead and balance out what looks to be an increasingly large revenue package that you are likely to go ahead and consider later today. So we ask you to go ahead and view it in that context. Last thing I'll say is one point I want to make that the trial lawyers had talked about, that it's the insurance companies that are not passing along profits. Well, there are two, I think, easy ways to debunk that. If you believe in markets at all, you have to recognize that Illinois has among the most competitive insurance marketplaces in Illinois for workers' comp. It's not because I think they want to sell workers' comp, it's so that they've got to sell that to sell other products. But the other thing you have to know is that we hear the largest complaints often from our largest employers who are self-insured. There is no incentive for a self-insured who can do an awful lot of things with their time to be carping on workers' comp costs if it's not a problem. They do not buy insurance products, so consequently, if they save, it goes into their reinvestment. So the notion that it's simply insurance companies, we would definitely contend with. Finally, I'll go ahead and turn over to Mark and Jay for some technical comments here. I will tell you that by the end of next week, Illinois is going to be surrounded by right-to-work states. So I am not, and you know what? If we can get our act together, they will need to be right to work in order to compete with us. But right now, we don't have our act together. So we need to get something together that's really meaningful. I know it's hard, but if it was easy, employers wouldn't have had to complain for the last 15, 20 years about this issue. So we very much want to see the ball go forward. We do appreciate very tough efforts from the president and the leader. We commend that. We want to see a process continue, but this package as it is unacceptable, and we ask you to vote no. Thank you.
Thank you. Mr. Denzler?
But Illinois does have the 8th highest cost when it comes to workers' compensation. The impact, particularly on the manufacturing sector, and its numbers that Greg Bays and the IMA have been talking about since last year, but since June of 2009, when you look at the other states in the Midwest, heavy manufacturing, Wisconsin's added 170,000 manufacturing jobs, Indiana 79,000 manufacturing jobs, Ohio 83,000 manufacturing jobs, Wisconsin 44,000 manufacturing jobs. During that time, we've lost net 1,600 manufacturing jobs. So we have a lot of things in the state that we've talked about before. We're very attractive. We have a central location, a great workforce, transportation, infrastructure. But for our members, workers' compensation is oftentimes the holy grail. That's what we hear about on a regular basis, and hence the need to get a strong workers' compensation package is part of this grand bargain, if you would call it. Going through some of the outline or some of the things that are in the bill and seeing the amendment this morning, again, the whole system should be something where we can reduce costs while continuing to make sure that workers get good care. I know it was mentioned that causation is off the table, but then going to some of these cost factors, certainly a medical fee schedule, we think further changes can be made. We appreciate that that's discussed in the proposal. We would prefer a Medicare-based or Medicaid-based fee schedule. The majority of states that have this, nearly 3 dozen, use that. Illinois' medical costs are certainly significantly higher than most states, and when you come to that point, we don't think, based on other states, there's an access to care issue. We would argue that when you're paying 300% higher than private insurance for the very same surgery, I'm not sure there's 300% higher cost doing the paperwork or the snail mail that was discussed. Certainly the AMA guidelines, and I know it sounds like continuing discussion on that, but using the AMA report is the sole factor we think is important. There are other good things in here talking about the PPD freeze, but again, just in totality, we're appreciative of the effort that you've taken. We're appreciative of the step. We look forward to being a part of the continued conversations, so hopefully we can get there. And again, thank you for your leadership. Happy to answer any questions. And I also, thinking Senator Raoul and Senator Connolly, who we've spent many, many hours together over the last 5 or 6 years on this, so also acknowledging all of those discussions. Thank you.
Mr. Shadegg, I don't have a witness slip from you requesting to testify.
I will submit when I apologize. I thought I
on
had
whose
one in.
behalf are you testifying?
The Illinois Chamber.
Now, the Chamber's just testified, so we're trying to wind things up here. Just want to make sure.
Let me just add, I won't repeat what Mark or Todd has testified to. I would just like to say, in the terms of making the package better, one of the concerns that employers have raised, and I know it kind of sometimes falls under this causation issue, but I would rather say it's about the case law that we have had to be we have been dealt by our court systems. It's nothing that the legislature has done, but it's been the interpretation not only of the 2011 changes, but also prior to the 2011 changes that have expanded liability for employers. So it's a traveling employee. It's the intervening causation. It's neutral risk versus positional risk. It's those kind of issues that have really hurt the employer community, and I hate to hear that that's come off the table. I know that during the negotiations, we had codification of that bad case law, which was not acceptable. I mean, that was not, in our estimation, any kind of answer. But to then not codify means that we also are living with the bad case law. So I would urge you to reconsider trying to bring those issues back to the table. I know they're tough discussions and negotiations, but that would be a critical component in addition to what Mark and Todd have said is needed to get to a real reform on workers' comp. So I appreciate the opportunities, Mr. Chairman.
And we have another guest at the witness table. And you are?
Michael Lucci, Illinois Policy Institute.
Okay. If you could please testify briefly.
Certainly. So we are testifying on behalf of more economic opportunity in the state, also savings for taxpayers. This is significant cost to taxpayers. The reason we're opposed to this bill is we don't think that it's touching a lot of the main issues that do need to be touched. Workers' Compensation Research Institute report, which details the max and min benefits for total temporary disability, permanent partial disability, all these items. They have us ranked as the 3rd highest in the country for the max on TTD. They have us ranked as the 4th highest in the country for the minimum replacement rate on TTD. And I would point out, if the minimum wage in the state of Illinois goes up, then the minimum wage replacement for TTD will also go up significantly because it's tied directly to the minimum wage. What has happened with some of these minimums that we have for TTD and then PTD in particular is folks end up getting more take-home pay when they're on workers' comp than when they're actually on the job. That's because they get 100% of their wage replaced, and it's untaxed on some of these workers' comp parts, specifically in the PTD and the TTD. So this is not a good incentive for workers. It's not good for businesses. It carries on costs significantly. The other item that we think, I think has been studied but should be studied and considered more in this legislation is the item with physician dispensing. There's very good research from Johns Hopkins researchers saying this is leading to the overprescription of opioids. And when you have the overprescription of opioids, you have people staying off work significantly longer than when they go to a physician that does not directly sell the opioids to the worker. So this is, in our opinion, very anti-worker that these workers are being exposed to the overprescription of opioids because there's a financial incentive to overprescribe opioids. So I know that there's the idea of a formulary. In other states, they've just flat out said physician dispensing can't occur outside of the first couple days of an injury. So you could get the emergency care, but after that, you have to go to a pharmacy. And other states, particularly when Florida did that, they saw the prescription of these opioids from physicians drop dramatically after they made that legal change.
The study you mentioned that had us ranked number 3 on a couple of things, were we ranked lower than 8 on other things by chance?
So the Workers' Comp Research Institute report, it's just looking at our maximum TTD replacement benefit. It's not looking at a total cost. It's not looking at, for example, the medical costs. It's just looking at the wage replacement costs. I do think that there is evidence that these other gentlemen have mentioned that on a number of medical benefits, we are significantly higher, 300% higher. So we would ask, if we're 300% higher than Medicare, why are we looking at a 10% cut? And on that item, we would push more towards looking at group health reimbursement rates or Medicare reimbursement rates, real transactional rates in the market as the basis for the fee schedule rather than billed or charged rates.
But my point was if we're ranked 3 on a couple of cost drivers,
Sure.
the TTD and whatnot, but we're ranked 8th overall, that suggests we would be significantly lower than 8 on other things, which might suggest we're doing some things better. It seems in isolation to highlight those 2 doesn't tell the whole story, and perhaps we should figure out what it is we're doing better than other states. So, questions for this panel? Senator Radogno.
I just wanted to comment on Jay's points regarding codification or not codification of some of these bad decisions. I think we all agree there's been some bad decisions. And so we contacted an attorney who does the respondent's piece of this, who's very, very knowledgeable, and actually has, I think, been really helpful in bringing us together on some things. Gave me kind of a different way of looking at whether or not we ought to codify some of these things. Because once we codify them, in some instances, we open up whole new unanswered questions that end up going to court. And as I understand it, the courts at this point are making better decisions with the facts that they're getting. And so what I don't want to set up is a lot of extra challenges that don't need to be there. Now, that was a new way of thinking for me. I don't know if you have a response to that or if you'd like to speak with the gentleman that's been assisting us with that.
Just a quick comment. I would say that given the choice of codification or continuing with the current bad case law, I think we'd go ahead with current bad case law because maybe we can change it in another decision down the road with a different court. But given the way the courts are set up, and we have proposals out there to refine and help the process for appeals beyond the commission that we would like also to see kind of in the mix. Because we're, as I said earlier, it's not the actions of the General Assembly that have hurt us over the last 15, 20 years. It's the courts. And we have an appellate court that has not given very many decisions to the employer community, has found for many, many, many times, and in the recent last 2 years, another 24 decisions, maybe a handful went the employer way. The others all went to expanding the law from an employee's perspective.
Other questions for this panel? Senator President Cullerton.
The Chamber of Commerce, Jay, maybe. Do you remember the major workers' comp bill that we passed in 2011? Did you guys support that?
We were neutral.
Neutral?
Yes.
Because it didn't go far enough?
Yes.
So we're trying to get you to neutrality in this one, too, right? You're never going to be for it, right?
No, absolutely not. I mean, I think...
If we gave you everything you wanted, you might be for it.
No.
You wouldn't be for it if we gave you everything you want?
No, let me just say, there are some improvements that have been made in this bill, but again, we think they could go further.
Thank you.
Any other questions for this panel? Senator Rowell.
I just want to, with regards to the TTD, I just want a clarification. You mentioned, I want to make sure are you challenged with the notion that a legitimately injured employee would get 67% of their wages?
No, I'm saying that some workers get 100% of their wages untaxed. It is, in general, it is mostly 2/3. Like the meat of all comp claims are 2/3 of lost wages untaxed, subject to a minimum and a maximum. I'm saying that in certain levels on the minimum, people get 100% of their wages untaxed. I believe that's the case for public safety workers as well. For police and fire, they get, for their first year of their injury, I believe they get 100% of their lost wage untaxed. So effectively, an increase in take-home pay.
Okay, so you want to drive down the temporary compensation for public safety workers?
Our position is to just hold even on take-home pay.
Okay.
So not increase take-home pay for injuries, not decrease take-home pay for injuries, just hold it even.
And real quickly, Mark, on the, I know we've had this conversation on and over again about the AMA impairment. the AMA guidelines do indicate that AMA impairment shouldn't be considered in isolation. They specifically say you should consider other factors like age, the employment, and which are the factors that we have in our law. So if you go by the guidance of the AMA guidelines themselves, they say you should consider these other things that we have in our law. Am I right or wrong about that on page 5 of the AMA guidelines?
I'm not going to argue with your citation on page 5. What I would say is we think the impairment rating can at times be used as a sole factor. I think we've talked about the Continental Tire case, for example, in Mount Vernon, where someone got a 10% award even though they were back on the job literally within a matter of days, and had no impairment, and the impairment rating came back as 0, and they were still given an award of 10%. And so I think we just have a fundamental disagreement.
So you're saying that there are cases where we should totally ignore the employee's occupation?
No.
Senator, if I might, no, I don't. I think all those factors should be considered when you're looking at disability. I think the AMA guideline impairment rating is one basis, but for the fact of Continental Tire, the courts, again, another decision that has gone against the employer community, basically said that we can't use just the 0 impairment rating, and there wasn't really very strong justification for the higher disability rating, having taken into the other factors.
But that's a different question. See, so that a court said that doesn't mean you ignore the occupation, doesn't mean you consider those things. So you consider those things collectively along with the AMA impairment rating to make your decision.
But I think in that particular case, you had a 0 impairment rating. The other factors were taken into consideration. A higher rating was
Jay,
on disability.
There's a whole universe of case law that falls all over the place. That doesn't mean we change our law to say to basically say you can just consider impairment, and the conclusion of that means that you can ignore the age, you can ignore occupation, and you can ignore these other things, and you can just consider impairment, which the guidelines themselves say you should not do.
I would say that when you have a situation where an injured worker has a 0 impairment rating, goes back to their job that they had, they got their TTD paid, they got their medical paid, there is no loss of future earnings, why shouldn't the impairment rating be the only factor then used?
For that case, potentially, it's not the only factor. That arbitrator can consider the age and say, oh, there's nothing about age that'll change my opinion. They'll consider the occupation. There's nothing about the occupation that'll change my opinion. They consider the IMEs. There's nothing about the IMEs that's going to change. And so based on all that, I'm following the impairment. But it's not that I've ignored these other things. If you put it in the law that you can base your decision only on impairment, you're opening the door to say, hey, I'm going to ignore these other things.
I see your point, but I think there's a way to also address the Continental Tire decision so that the employer who does get a 0 impairment rating can feel that is going to be a 0 impairment or 0 disability when the fact is that individual worker goes back to their old job, has not lost any pay, has everything paid for, and there's no loss of future earnings.
And I'm saying your suggested way is not the way.
Okay.
You guys have clearly spent a lot of time recently in the tall grass. I think you lost most of the committee in that exchange. So we'll excuse this panel, and we'll bring up the next one. I think the only witness that I have still requesting to testify is from Citizen Action. Were there others who were trying to testify? Come on up and... God bless you, William McNary. Thank you.
Good afternoon. I know it's been a long day already, and it's still early afternoon, and it's early in the year. My name is Steve Schneider. I work for the American Insurance Association. Today, along with Kevin Martin from the Illinois Insurance Association, we're here representing most, if not all, of the insurance companies doing business, workers' compensation business in the state, including those who are members of the Property Casualty Insurance Association and the National Association of Mutual Insurance Companies. And we found ourselves with quite a dilemma in examining Senate Bill 12. We congratulate Senator Cullerton and Senator Radogno in bringing forward some key issues in Senate Bill 12. But as our customers just previously indicated, the businesses who buy our product indicated, there are a number of provisions in the bill which are troublesome, and they are indeed troublesome to us. Yet nonetheless, we felt there were areas in the bill which were brought to the forefront, namely the fee schedule, the call for a drug formulary, some other things in there that we thought were beneficial enough that they ought to be considered, and we ought to give them as much support as we could on those particular issues. And so we would ask the committee, as you look at this bill, and if you're considering further changes, to consider at least 3 changes, possibly 4 changes to this bill. First, a Medicare-based fee schedule, not at the Medicare rate, but at 175 or 180%, as is the norm in 29 other states in the country, would be an appropriate change. The fee schedule was first enacted in 2005, took a couple years to put together, was tweaked in 2011, was the subject of proposed legislation in 2015, 2016, and here we are in 2017. Could change a lot of that, add consistency and durability to the medical fee schedule process by implementing a Medicare-based fee schedule. We urge that you not dismiss that out of hand, that you consider it. And when you consider that some of the charges that are being made for some of the medical procedures are already at 200 and 300% of the Medicare rate, we urge you to look at that issue. Secondly, we congratulate you in this bill for putting forward a call for a closed drug formulary. That has been a growing issue of concern for employers and insurers, municipalities who are self-insured over the last several years. Closed drug formulary is very important. We urge you not to do it by rule necessarily, though, so that you don't find yourself in the same box that you do with the fee schedule of having to tinker with it every other year. There are specific drug formularies that exist out there, one notable one specific to workers' compensation by the Work Loss Data Institute that we urge that you consider putting in as a statutory recommendation, because that one will work and should serve well over time. Some other states, I don't know how many, other states have done that already. Last but not least, I urge you to take, or not last, but almost last, I urge you to take a look at one of the provisions you've teed up dealing with e-filing of claims or e-claims. In there is a new time frame that is imposed on payers, employers, and insurers that basically constrains us to having to pay a medical bill within 5 days. How is that so? Now we have 30 days. Under this new time frame, at least as we interpret it and understand it, the medical provider has 15 calendar days or 21 business days to give us the information to pay. Therefore, we have to react in the next 9 days. Out of those 9 days, that could be as few as 5 business days. That's a pretty short time frame to carefully evaluate and digest a request for payment from a medical provider. We urge you to take another look at that section. Last but not least, there was, in the original bill anyway, a call for a WEAR, a WARE Commission, the Workers' Compensation Edit, Alignment, and Reform Commission, to be composed of 4 legislators, 4 respondents' attorneys, 4 petitioners' attorneys. We provide 75% of all the insurance in Illinois and about the same level throughout the rest of the country. We could bring, we believe, some expertise to the table if you were to include us or our representatives on such a commission going forward. We urge you to consider these 3 points, 3.5 points that we've made on this legislation, and look forward to working with you as you go forward. I would only note that there were some, I think, unsubstantiated claims made against insurance companies by some of the earlier witnesses about premiums not having gone down since 2011. And I will only make this note. The National Council on Compensation Insurance files advisory rates with the Department of Insurance where they are thoroughly reviewed, investigated, and justified. Over the last roughly 5-year period, those rates have fallen 30%. The Department of Insurance itself, in May of 2015, I think it was, or 2016, I've lost track now, identified that over 200 insurers had filed further deviations or decreases from those rates. And yet you might scratch your heads and say, well, why has total workers' compensation premiums that have been collected in the state over that same period slightly increased? That's because the unemployment rate has dropped 41% over that period of time, And there are a lot more people working than there were at that time, so you have to pay for people who are at work for workers' compensation. There is a total increase in the amount of dollars that are collected under that system. I'd be glad to answer further questions, and I would turn it over to Mr. Martin if he's got further comments.
Thank you, Mr. Schneider. I apologize, I didn't notice your witness slip. Your associations are taking no position on the bill.
We're neutral on this particular legislation. We understand what you're trying to do with some of the key points here. Some of them are customers, and we share the concerns that our customers have on a number of the other provisions in there.
Senator Raoul, did you have a question for Mr. Schneider before we hear from Mr. Martin?
Yeah, just briefly. I was in particular listening to your closing statements about basically indicating that the 2011 reforms have driven down those costs by what percentage? 30%? Okay. And then you indicated that the change in the unemployment rate is the factor that has led to the increase in premiums. I guess my question, and thank you about validating the effectiveness of our workers' compensation reform of 2011, because many have said that, it has not had like a 30% impact that it in fact has. But with regards to your second point about the unemployment rate being the factor leading to the increase in rates, how do we know that?
If more people, the unemployment rate increased 41%, and of those jobs, of the material and the research I've seen indicates that some of those are higher paying jobs, so it's not just a dollar-for-dollar transaction, that there are more dollars being charged because there are more people at work. And you have the underlying premise for the computation of workers' compensation is payroll.
So, but I guess my question is, how do we really know that factor is what's with all factors, including our reforms included? How do we know that? In other words, is there anything, there's been a lot of talk about what's done in other states. Is there anything done in other states with regards to insurance rate regulation to make sure what you're saying is in fact true, that's more aggressive than what we do in the state of Illinois? Because we want to make sure employers inure the savings that the full savings that our reforms, our effective reforms that we passed on a bipartisan basis in both chambers in 2011, that the employers are getting those savings, because we're being told that everybody's leaving the state because what we haven't done in workers' comp reform in the state. And I'm learning from you that we've done something quite effective in terms of reducing things by 30%.
The most effective regulator is competition. And in Illinois, according to the Department of Insurance, there are 332 insurance companies competing for that business. Competition is the best regulator that exists out there.
Yeah, I appreciate that. But the other part of my question is there anything done in other states, rate regulation-wise, that's more aggressive than what we do in the state of Illinois?
Sure, and in those states, there are far fewer competitors competing for that type of insurance business.
And what kind of things are done in other states with regards to rate regulation?
Everything from having the state be the only insurance company and be a government-imposed system to other types of government-imposed price controls on insurance products.
And are there any of those states, because we've been talking, there's been some talk about getting below the rates of other states. Are any of the overall costs of other states, are any of those other states that have lower costs than the state of Illinois?
I'd have to examine that. I don't know.
Okay. Can you get back to me on that?
Certainly.
All right. Thank you, Mr. Martin. Could you please file a witness slip if you haven't, because it's not showing up here on our side of the table.
Thank you, Mr. Chairman. I'll be very brief, and I think I just want to follow up on what Steve had just commented on, and that is the whole effect of open competitive marketplace in Illinois. You have to look at it in a historical perspective, in that if you look at the benefits that competition brings to the system, it's substantiated by anything else. If you want to go back to 1982, when I think only a few of us were still around, that dealt with a crisis that existed in Illinois, and that was prior to in 1983, they had a prior approval, very strict rate regulation on companies. There were probably only a dozen companies that wrote work comp in Illinois. There was an availability crisis, there was an affordability crisis. It led to some very smart people being able to say, you know what, let's open this system up. Let's open it up through an open competitive marketplace. It worked. That's why we have the number of companies that exist here in Illinois. It's what requires, every company on a yearly basis to compete for that business, and it helps bring down the costs.
Any question? Senator Raoul.
Well, I'd just like to say that I appreciated that we've created a friendly business environment to bring businesses into the state of Illinois.
If I'm seeing no further questions, thank you, gentlemen, very much.
Thank you.
President Cullerton. Oh. We're going to turn now to Senate Bill 11, President Cullerton's bipartisan pension